kill yourself, and I want to watch you suffocate, and your family hates you. Socks not being in the closet. The defendant punched the complaining witness with a closed fist on her foot twice.
You know, Mr. Fritter, let me tell you something now. You scare me. Mr. Fritter, look at me. So if I go like this, is that threatening or harassing? Look at me 3 times a week. Holy freaking.
Pause right here, because this is where things go from disturbing to legally serious. When someone sends messages telling another person to kill themselves, that's not just cruelty, that's harassment with potential criminal consequences. Courts look at pattern, intent, and fear, and this case checks every box. Ask yourself this: if someone sent you 50 to 60 messages like that, would you feel safe or trapped? Because the law is about to answer that question very clearly.
Mr. Fritter, you're charged with harassment. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay, please. Shh.
September 19, 2024, an officer conducted a follow-up in regards to an assault on a family case. Upon further investigation, the officer made contact with the complaining witness, who reported that the defendant had been harassing her since September 18, 2024, by sending her videos, voicemails, and text messages containing horrible remarks, approximately 50 to 60 messages in total. In the voicemails, the defendant curses at her, asking, "Where are you? Why the fuck aren't you at work?" and calling her various names. Additionally, the complainant showed the officer text messages of the defendant telling the complaining witness, "Kill yourself, and I want to watch you suffocate, and your family hates you." The complaining witness indicated that the continual harassment is making her fear him even more. Complaining witness was able to give officers the defendant's identifying information and positively identify the defendant as a person who has been harassing her.
I see that he has also picked up a felony assault against this complaining witness as well.
Yes, sir.
Okay, what happened in that one? And I'm assuming it's the same date as this one, so I'm assuming it's out of the same transaction?
I'm not sure. So it says that I don't believe so. It says that on September 18th in Harris County, officers were dispatched to an assault. The complaining witness advised that the defendant came home upset about socks not being in the closet.
This is a critical moment. Notice how the judge is piecing together 2 separate cases, harassment and felony assault, from the same relationship. That matters because it establishes a pattern of abuse, not a one-time incident. And legally, patterns change everything: bond decisions, protective orders, even future sentencing. So here's the real question: how many warning signs does the system need before it stops giving chances and starts giving consequences?
The defendant punched the complaining witness with a closed fist on her foot twice, twice on her right thigh and twice on her left thigh, causing pain. The complaining witness advised that the defendant grabbed her by the arm and forcibly shoved her out of the house, throwing her on the porch. She advised that she felt pain, and she advised that this has been an ongoing issue for the past 2 years. The officers observed purple and green bruises on her arm, foot, and her legs. The bruises were green, purple, and red, and of significant size.
Is there a no contact order in this case?
Judge, who's the defendant?
This is Mr. Fritter. He hasn't harassed, Mr. Fritter, let me tell you something now. You scare me. And you scare me something good. You have, since 14, assault, trespass, deadly conduct, assault, DWI, forgery, and now a harassment and a felony assault.
Judge, there has been a note filed, but there is no protective order in this case.
Is there no contact in the felony case whatsoever?
I'm checking all conditions. It's no threatening or harassing at this time. Would ask if that be a no contact in this court, Judge.
I don't see that the rip has been.
Are you Miss Lisco?
Yes, sir.
That's Miss Lisco right there. Come up, ma'am. Come up. I'm sending you for a drug and alcohol test right now, Mr. Fretter. I want to protect you as much as I can. No one has to have this kind of treatment whatsoever for any reason. And I will do everything in my power to protect you. All I need you to do is tell me. All I need is please give me the word. Mr. Fritter, look at me so much. Can you imagine what life is like when someone has to walk on eggshells because they have the fear that if they make someone mad in the smallest respect of having socks not in the damn drawer, they're liable to get a beating?
This is the hammer coming down. A no contact order isn't a suggestion, it's a legal landmine. One wrong move, one look, one message, and this man is back in a cell with a six-figure bond. The judge is making something crystal clear. Power ends here. But here's what I want to know from you. Do you think strict supervision actually protects victims, or does it just delay the inevitable when someone refuses to change?
Can you imagine what life is like to live with that kind of fear? You're going to live it with me now. Because one false move, I'm going to make your bond so high your head will spontaneously combust. But no one, and I mean no one, should have to live with that kind of fear. I'm sending you now for a drug and alcohol test because I want to know what, if anything, is in your system. And I don't know if I'm going to allow you to have contact with Miss Lisk. But if I find that you treat anyone or put anyone in fear or put anyone in harm's way, so help me, I will grow horn and tails because I will be so upset, and it will be on you. Do you understand?
Yes.
Abel,
Yes, sir.
I'm going to keep Mr. Fretter so close to me that it's just ridiculous.
Yes, sir.
I'm entering what's called a magistrate's order for emergency protection. This is a court order that identifies her as a protected individual. You're not to have any kind of communication whatsoever. You're not supposed to have you will not have any threatening or harassing contact. What is threatening or harassing doesn't matter what you think is threatening or harassing. It's what she perceives. So if I go like this, is that threatening or harassing? It most certainly is. And it's enough for me to put you in jail and make your bond $150,000, maybe 50, maybe 20. But I will do, Mr. Fretter, I will do everything in my power to protect every single person of this county. And I don't care if you're kicking, screaming, crying because you go to jail and don't have anyone to bond you out. I want to protect you, ma'am. And you know, the problem is that now that he's picked up these two cases, times will be just even more stressful. We have these protective orders. They're basically like cooling off motions so that, you know, you can separate, enough time will pass. People can kind of cool down, you know, so they're not under the stress of the excitement and then unleash on you. The last thing I want is for you to suffer any kind of harm whatsoever, you know, and I that's all I want. You know, all I'm asking is how things should be normal. Like, I'm not asking him for him to do Pythagoras theorem here. So I don't know. You know, what I'd like is if you please just talk to our DAs here. But I'd like you to have their phone number at the minimum so that should anything ever whatsoever, all you have to do is let us know. And then I'm here for you. And I want to make sure that you're okay. You know, I've given him a lawyer. He knows what's expected of him. And I'm going to drug test him like crazy to make sure that he's not using alcohol or dope. In fact, I mean, I'm going to test him 2 times a week, I'm setting him now because I want to know what, if anything, is in his system, and then we'll go from there.
Judge, he will come back positive, but that's prior use from.
What? What were you going to test positive for, Mr. Freder?
Marijuana
Okay.
and ketamine and probably some other stuff that could have been in the ketamine. But I mean, straight up, that's probably it.
Mr. Freder, I'm going to test you. These are your bond conditions that are going to apply to you now. And if you fail to live up to these bond conditions, I'm just going to let you out. That's it. You will appear to me here 2 times a week to take drug tests. And if I find anything is in your system, and I don't care what it is, I'm going to lock you up. You're ordered not to use any kind of dope or alcohol. And if you can't get this monkey off your back, because I am now giving you the opportunity to do it on your own. If you're incapable of doing it on your own, then I'm going to do it for you. Do you understand? No dope, no alcohol. And when I mean no alcohol from any source. No isopropyl alcohol, cakes, candies, foods, gums, energy drinks, tequila, lollipops, hair dye. I've heard it all, and I don't care. You come to me test positive, you'll stay with me. I also want you 3 times a week to do anger management classes so that we can deal with the anger issues. Look at me. 3 times a week. And I want a piece of paper showing me that you've done it, the date, time, location of where you've done it, so that I can verify that you've done it. And if you don't do it, you will stay with me. You now have the opportunity to address these things on your own. If you don't, you will be doing it with me. And if I get one breath that she's been mistreated in any way, shape, or fashion, holy freaking moly. Okay? Right now. And then, ma'am, if you'd be so kind, please, I'll have you speak to them here momentarily. Rachel, this is my card. If you ever need anything, all you have to do is get in contact with me. And I'm here for you. Whatever you need, anytime, day or night. I don't care. You, really. Okay. First things first, though, is I have Mr. White that's been representing him.
Right.
And I guess, did I grant your motion withdrawal, or we're having a hearing now?
We come back on Monday.
All right, so come on up.
So Will reached out to me on Wednesday. I spoke with Michael on Friday. I spoke with Michael on Wednesday. And so basically the understanding is that Will's gonna sub in and take over and I guess possibly
Are you
resolve the
hiring
case for
on?
today.
I'm hired on to this new felony
Okay.
case that triggered this whole deal. I've agreed to sub in on this case to work out whatever's going on here, and I've been talking to Michael about that. The felony case is bogus for a lot of reasons, but talk to the state about this as well.
Well, hold on.
Okay.
Putting the cart ahead of the horse.
Okay.
So you went out.
Yes,
Okay.
sir.
You're out.
Okay. And I'm in.
Well, I don't know.
Okay.
You want me to appoint him a lawyer, or do you want to?
I'm taking it pro bono because I'm hired on the felony and we want to just resolve this DWI deal today, probably.
Well, because here's the deal. I'm putting him in jail. You picked up a felony while you're on bond for a DWI. You're not supposed to pick up any new cases. You've now picked up a felony, an injury to a child, and it's just now coming to my attention, even though this thing's from November. I'm revoking your bond. Goes with you.
Which one's that? Okay.
Let's talk.
May I be excused, Your Honor?
Please.
Thank you.
Thank you, Mr. White. You did file a motion to withdraw, correct?
I didn't.
Mr. White?
He didn't file it.
Aaron,
I thought you
did you file a motion to withdraw?
Yes, I filed it last week.
I saw it.
I don't have one.
It's on Douglas.
Oh, I just see an appointment form from January.
I see the motion to withdraw. Yeah, it's there. Do you see it, Seth? Do you need a cause number?
I have the 2500939. Oh, no. Okay.
Yeah, can you put it in the queue so I can sign it? Okay, all right. Tell me. It doesn't,
I know.
look, there's a certain standard.
I
You pick
understand.
up an injury to a child. I don't know anything about the case. All I know, he's picked up a third degree felony, and it's a serious charge. It's not like it's a
But, yeah.
trespass, but it's, so,
But you know that these charges can be
I,
empty.
but I don't know that for sure. All I know is that he's picked up a felony. He's not done squat while he's on bond for this thing. He's literally been riding free, not doing anything for the last 4 months, 4.5 months.
Has he been blown in?
Nothing,
Nothing?
done nothing. He's not tested. He's not had, he's literally done nothing. So anyways,
State's offered a time served. I talked to Michael about it. I'm like, hey, my plan coming in was to try to get him back on PTI
I think
because
they're like,
the felony is so ridiculous. It blows my mind. But regardless, I was talking about that this morning. He's like, honestly, Will, he's like, the PTI it's not feasible for me to do. He's like, is there any other alternative?
if you want time, take it maybe a day.
I don't need the time. He wants to time serve it today, Judge.
Well, if that's what he wants to do, then that's on him.
Okay. Would the court accept that?
Yeah,
Okay.
absolutely. I mean, look, far be it from me to, because that's what we would do in every case.
Right.
Any case that comes back here. And I mean, obviously, state, you need to also be happy as well, right?
Yes, Your Honor.
But it's on you guys. So I'm on board if they're on board.
Okay. I will run it by him just to make sure and then we'll get paperwork started. Thank you, Judge.
Mr. Douglas, you're charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. You know, it doesn't make me happy to put people in jail, but if you're a danger to my community, I only have one place for you. Do you understand?
Yes, sir.
You need to understand something very serious now, that this DWI is going to go on your record. It'll be there for the rest of your life. It's even there after you die. You get pulled over again. First thing an officer does, they're going to look at your record. When they see this and they look at the other, what do you think they're going to do? Think they're going to be happy? Think they're going to give you a hard time? Probably. So if you even have the most faintest remote smell of anything funky, it's probably not going to go well for you. You need to understand that from now on, it's a minimum of 90 days in jail. Do you understand?
Yes, sir.
You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to test on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, it will go on your record. You can never take it off. Do you understand? You still want to do this? How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
Is it true or untrue that you had a .15 or above? Okay, so true to the enhancement. You need to understand one more thing, Mr. Douglas, is that we all make mistakes, right? Everyone's human. But when you continue to endanger other people's lives, there are no more mistakes, they're actions. And when you keep making boneheaded actions, we have longer sentences, bigger jails, more fines. This carries a fine of $4,500. And if you don't do it, you sit in jail 1 day for every $100 you owe. So you can imagine how much jail time you will do on a $4,500 sentence. On a second DWI, it's a $6,000 surcharge. Get a clue. If you want to get lit, great. Take an Uber. $40 anywhere you want to go in this city. You understand? What do you do for a living?
Work at a warehouse.
How much money do you make a month?
I'm sorry. 16.
Look, I'm going to waive your fee for you today. You come back with another DWI, get ready, because it's just, do you understand? Get a clue. Good luck. Oh, I am suspending your license for 180 days, sir. Do not drive until you get a license. All right, sir. Good luck.
Thank you, Judge.
Thanks. Good morning, Ms. Howard. So you are wanted out from another state. Your lawyer is asking me to set you a bond. I don't know. You know, I've never met you before. I don't know you. I don't know how dangerous of a person you are. I don't know if I give you a bond, are you going to go back? I don't know. I know that you're going to tell me it's little gumdrops and rainbows but how you are on paper tells me who you are, because everybody tells me one thing, but when they get on paper, they're a completely different person. So I got to get to know you before we set you a bond. So Amy, tell us about Miss Howard.
Yes, Judge. She's wanted from Navajo County, Nebraska, for burglary, felony 2A, theft of lawful taking 5,000 plus, and conspiracy to commit a class 2A. State is opposed to a bond based, one, on the charges that she's wanted for, two, on the fact that she has previously been a fugitive in your court.
Oh, really?
Yes, from South Carolina for robbery.
What happened with that case? Do you know?
I believe they picked her up in that case. Yes, they picked her up in that case. Her most recent conviction was also back in 2024 for an beating with a motor vehicle out of Fulton County. Day has also indicated to me that she is on federal probation right now.
She's on. That's out of Arkansas, Judge. That's what she's on bond for. She is on the leg, has the leg monitor on for that.
What's she on federal probation for?
What are you on probation out for?
I think like a drug conspiracy charge.
Where?
A conspiracy?
Out of where?
Arkansas.
That's the case at Arkansas, Judge.
Possession with intent to distribute, it looks like. Her release date is 2029.
So is that different from what she has in Nebraska, the federal probation case, or are you talking about, is that the same one?
Nebraska should be different. What she's wanted for right now is the burglary. So the basis of the probation, the federal probation would be the possession with intent to distribute.
Got it.
That's out of Arkansas. When she was in Arkansas, Nebraska put a hold on her, but they didn't come get her.
So let's get this right. Here in Harris County, in 22, you have a burglary of a building, a failure to identify oneself as a fugitive from justice, meaning you're trying to evade law enforcement. You have a prior fugitive case from 21. You have another failure to ID from 2024. You're on federal probation in some other state. You have another open burglary in Nebraska, and you had an evading in a motor vehicle in Montgomery County. And you want me to set you a bond?
That's it. All right.
Should I? Really?
Ms. Howard, how long have you been in Houston? How long have you lived in Houston?
All my life.
Okay. You currently were on a probation, and you have a leg monitor pursuant to that, correct?
Right.
Okay. And you had a leg monitor on you when they pulled you over, is that correct?
Right.
Okay. Did you attempt to flee from at that time?
No.
Okay. And that's what, you're aware of that case up in Nebraska?
Not until my lawyer had told me to turn myself in, but they said it was gonna be a court day for that.
I don't want you to talk about the cases now.
Okay.
How old are you, ma'am? How old are you?
I'm 24.
You're 24 and you have all those priors. You scare me, Miss Howard. You truly do. Because if I put my name on a bond, I don't want something bad to happen. And as history dictates, and as the paper says, it's, sometimes we have to protect people from themselves because they're their own worst enemy. You know, you scare me. I can't give you a bond. It's hopscotch with states with the criminality. It can't just happen. And you have a prior one from here as well. I just can't do it, man. It just, at some point, it comes time, the bill comes due. That's now.
You already executed a waiver, Judge.
Okay. All right. Thank you, Ms. Howard.